So, to kind of summarize where we are so far, we kind of started with your history. We worked into how that tied into Calyx and how it generated revenue, how you've kind of turned it into what it was in 2013/2014 into 2020, and also your goals for 2021. I guess the main missing piece, which is probably one of the, I guess it's the elephant in the room, is the FBI case, and we kind of talked about it earlier. But I haven't done much research into the FBI case. I know about it on a broad level. I know you were served a gag order. I know that you won in some regards, though I know obviously you weren't successfully able to remove the Patriot Act. Though, to my knowledge, you did attempt to do that. Though, correct me if I'm wrong when you explain the story. But just any context, and if you can go through that story and kind of share with myself and the audience what happened there, because I don't think many people have actually been served a gag order and I guess survived the tale, kind of.
Sure. No, your summary was actually totally right. I don't think you got anything wrong. You know, I ran this internet service provider, and as was the custom in those days, and largely still is today, companies that transit people's data, they tend to keep a lot of records on what's happening, what the people are doing, for a bunch of reasons. Sometimes it's because they view the data as a potential gold mine, that it has its own intrinsic value, like data mining. Other times it's for legitimate business purposes, like they want to be able to predict their growth. So they want to know how much, if they need X number of gigabytes of bandwidth this year, how many they're going to need next year, so that they can plan properly. So there's a lot of reasons why companies would stockpile data on people. Another reason is so that people can market stuff to those people, because an internet service provider or a mobile phone provider can really tell pretty much everything about what a person's interests are, what types of places they frequent, what types of things they buy, and by knowing all that stuff, you can figure out how to sell them more stuff. So this is potentially extremely valuable info. So I wasn't really doing any of that stuff. I wasn't really marketing. I wasn't selling the data. I wasn't doing anything like that. But it sort of was just common practice in. It's hard to explain why it was common practice to like save all your logs and keep all your historical logs basically forever.
I've read this. I've read that it was very common for pretty much every website and everybody to just store the data because you didn't know what it was going to be useful for in the future.
Yeah. And like, I mean, it goes back to just like the default setup of Linux. Like Linux was set up to log everything and then to rotate and compress the logs and archive them basically indefinitely. So like, unless you went out of your way to change that, with having the foresight to see that this was going to be problematic, like that was just how it was going to work out of the box. So we ended up having all this data. The government came to us at one point in 2004. What happened was I was sitting in my office working. I got a phone call. The person on the other end of the phone line said that they were calling from the FBI and that they had a letter for me. And I said something like, okay, but they didn't like explain how I was going to get it. I just assumed they said letter. I assumed that they meant they were giving me a heads up and they were going to drop it in the mail. But like I said, okay. And I didn't even know if this was real or like a prank call or whatever. I used to get all kinds of weirdos calling me. I didn't know if it was real or not. And I said, okay. And then I just hung up the phone. I went back to work and I didn't really pay it that much mind. But like within an hour, someone was knocking at my door, and it was an actual FBI agent who came to my office with this letter. So the guy wanted me to sign some kind of a receipt confirming that it was delivered. And before I even did that, I wanted to read it because, you know, it was like super suspenseful at that point. Here's this like gray-haired older man in a trench coat who pulls out this wallet with this huge FBI ID in it and stuff. I mean, it was like in the movies. And I read this letter, and it says that I have to give them all this data, and it says that I can't tell any person that they've visited me or asked for the data. And it doesn't even say that they're asking for it. It says that they demand it and that I have to provide it. So ultimately, it's like a 3-page letter. The whole third page is literally just a bulleted list of all the things I have to give them. And it's signed by a person that I ended up trying to look up and figure out who it was, but like one of the top lawyers in the whole FBI. And I actually said I had the presence of mind, and maybe this went back to my constitutional law, my one constitutional law class that I took. And I said to the agent, like, what about my lawyer? What about my business partners? You know, like, because it said I could tell no person. It was super absolute. And he said like something to the effect of like, I'm just here delivering the letter. I'm not really qualified or in a position to answer your questions. Something like that. Like he just refused to answer me and just acted like he was just a delivery guy. But he was clearly, you know, he clearly knew more than what he was telling me. I felt. Anyway, he didn't answer me. But the irony of that was like the question that I asked him right there hit to the heart of one of the central legal problems with national security letters, which is that prior to September 11th and prior to the Patriot Act, in order for the government to have seized records like they were trying to do with my company, they would have had to have gone to court. So you have a system of checks and balances. And the FBI would have had to have made claims in front of the court, backed up with evidence that they had some type of proof that a crime had occurred or was likely to occur, and that they had some evidence that there would be evidence that they needed to seize at this company. And then the court, the judge at that point, would typically either agree with their argument or would push back on them and would say like, hey, you know, this is really not convincing. You haven't really convinced me that they're likely to have anything. So there was a theoretically adversarial situation that they had to go in, where they had to convince someone from a different branch of government. You know, the FBI is part of the executive branch of the government under the president. The judicial branch is separate and independent, supposedly. This is what I learned about in school. So one branch has to convince the other one and get their approval before they can do this search. With the Patriot Act, they removed that. And this is all spelled out in the Fourth Amendment of the Constitution, right? It says that you can't search or seize anyone's papers without showing probable cause in a court of law. So under the Patriot Act, it says the FBI doesn't need to go to court anymore and doesn't need to show evidence and doesn't need to prove that a crime has occurred or is likely to occur. It just says that they can go to their printer and print out their own, essentially, search warrant. And all they have to claim is that the information that they think they'll get will be relevant to some investigation. And this is like a huge radical departure from 200 and something years of American jurisprudence and legal precedent. And the thing is, the American system is based on English common law going back like 1,000 years or something. So this is really like a huge departure from the system that we were all taught about in school. And when I looked at this letter that they gave me, the other question that I asked the agent, besides what about my lawyer, can't I talk to my lawyer, was why isn't, like, where's the judge's signature? Why isn't this thing signed by a court? And he just didn't answer me on that. Like, I got no answers from the agent. So the irony is, I'm not a lawyer. I never was. I took one law class as an undergrad at the City University of New York, like a public college. It's kind of like, not a prestigious, it's not Harvard, it's not Yale, it's like City University. But like in like 1 minute of like reading this letter, I already hit on two of the major constitutional problems with what they were trying to do. And then I did eventually sign the receipt because I wanted the guy to like leave. And so he didn't want to leave unless I signed. So I signed his thing, he left, but then I'm sitting there with this letter and then I'm trying to decide what to do. I was lucky in that I had a lawyer that worked for my company, mostly doing boring stuff because I had never had any excitement like this ever in 10 years of running the company. It had only been boring contracts and, where do I put up the posters that tell you about minimum wage or whatever, all the boring business law. I knew this lawyer. He was actually my friend before he ever became a lawyer. So like we had an actual personal relationship. And I called him up, despite that the letter said I could not tell any person. And I said I needed to meet with him. And he said, okay, let's meet so-and-so. So I went somewhere and met him. And I showed him this letter. But, the letter said that I could not tell any person. And here I was telling another person. But I knew from my one law class and from watching movies and TV all my life and having grown up in this country that you always have the right to a lawyer. And they can't tell you that you can't talk to a lawyer. So I felt confident that it was my right to do that. But at the same time, the letter was very plain, very clear, very explicit that I was not to tell any person. So I knew I was also in violation of what the entire FBI was telling me what to do, and like one of their top lawyers. So I was actually terrified in terms of doing this, but I didn't know what to do, and I didn't feel like I should just hand over. I knew I couldn't hand over the info on our client because it would be a massive violation of their rights. And I started to think about how a person that runs an internet provider or a mobile phone company or regular phone company has a huge responsibility when they're holding onto super private data. And so it seemed to me, and I started to see the big picture of what was happening in terms of the society's rule of law breaking down. And it seemed to me that this was obviously just not legitimate and they could not do this. So I asked this lawyer what to do, and he told me, you're completely right. This is not legitimate. They cannot do this. The Constitution forbids this. But you know what? Like he said, I'm just a simple business lawyer. I don't really do constitutional law, and you really need to talk to some specialists. And I told you when I started my internet provider that I had wanted to change the world and I wanted to work with people who were doing interesting stuff. And one of my clients was the New York Civil Liberties Union, which is the New York affiliate, the New York branch of the ACLU. And I hosted their site for free. They were one of many organizations whose websites my company hosted for free, just because we wanted to help them in any way we could. And we would do consulting for them, like help them figure out better ways to use email, have mailing lists, do this or that, whatever. Just it's hard probably for people to understand, but at that time, organizations like didn't even have websites or email. And so I was trying to convince them that they needed to start to use these tools. Because the NYCLU was our client, I was able in one phone call to get on the phone with them. They knew who I was, and I was able in this one initial phone call to get on the phone with their legal director. And I was sitting there with my lawyer, and we both called this legal director guy, and we were trying to explain to him what happened. And he said, get in a taxi right now and come down here and bring the thing with you. And so we did. But it started to get really scary So we go down to the financial district, way downtown in Manhattan, which is where their offices are. And we go up in this elevator to like the 18th floor or something, and we end up in this guy's office, and this guy's like, I don't know, 65, 70 years old, very serious lawyer. He's the legal director of this whole organization, the multi-million-dollar civil liberties, basically law firm, advocacy firm. And we show him this letter, and he's completely shocked, and he's never seen one. And he says, do you mind if I call another one of my colleagues in to look at this? And he calls the ACLU office, which is in the same building on a different floor. And a young lawyer comes downstairs. The guy's like my age. So at the time, I'm like, how old am I? 32? I think I'm 32. Yeah. I believe I was 32 years old at that point. But this young lawyer comes down. He doesn't even have gray hair or anything. And I was like, kind of like, like, you know, I like the older lawyer. I was like, I feel like this guy knows what he's doing. He's been around the block. This young guy came down. He was like my age, younger maybe, not even sure. It turned out though that he was a super hotshot lawyer who was like number one in his class from, you know, Harvard Law. And he also said he had never before seen a national security letter. They knew that these things existed. They knew it was part of the Patriot Act. They'd been wondering about it, but they had never seen one, and nobody had ever brought one to them. These guys said they wanted to take some time to discuss the whole thing with their colleagues, and they would get back to us. And the long story short, they came back to me a couple days later, and they said, we think you have a super strong constitutional law case here where you could challenge the constitutionality of what the FBI has done. And not only what was at stake was not only is the practice of using national security letters instead of court overseen warrants potentially unconstitutional. They said they believed 100% that it was unconstitutional, but that the entire Patriot Act could be overturned. And the whole thing could be ruled unconstitutional and basically repealed. So there was a huge amount of stuff at stake because so many things that the government was doing at that time in terms of spying on everyone, like all the stuff, a lot of the stuff that Ed Snowden was talking about was all enabled by the changing of the laws and the weakening of the systems of checks and balances that was done by the Patriot Act. And they said that if I wanted to bring a lawsuit against the FBI and the Department of Justice, that they would be happy to represent me pro bono, like meaning for no charge. But it was up to me, and like I was the one ultimately at risk, not them. And of course, the difficulty in doing this is that the letter still said that I couldn't tell anyone that I'd gotten the letter. So if you can't tell anyone, but I've just now, in this story that I've told you, I've gone and told my lawyer, and then we went and called the legal director of NYCLU, who then called someone from another organization, the ACLU, and they brought their lawyer in. So now it's like I've told 3 different people. I've broken this order 3 times. And now we're talking about going to court, telling a judge, telling the judge's clerks, and filing this case, and doing all these things where it was pretty obvious that the FBI was telling me just don't tell anyone and shut up. I had to think long and hard about it because I kind of figured I was possibly ending my own life and maybe going to just spend the rest of my life in prison or something, because not because I thought I was doing anything wrong, but just because the government seemed to be acting in an extremely, they were using like demonstrative violence, where they were like making examples out of people to make everyone keep in line. And I thought I might be sort of extending my neck out to the point where I would be made an example of. But, I was younger at that time, and I had less to risk than I do now. And so I decided to go for it. But I didn't know at that time that this was going to last for like 12 years or however long it lasted. I kind of thought that it was going to take a couple of months, maybe a few months. And so what happened was, like, we went to court, but of course I couldn't go to court because the whole lawsuit then was in the name of John Doe. So it couldn't even have my name on it. So I couldn't actually go to court because I couldn't admit that I was John Doe. And we win. Like, they make the ACLU makes these arguments. National security letters violate the First Amendment because they put a lifelong gag order on you that never ends. And that's called a prior restraint of free speech. And that's been ruled unconstitutional in the past in landmark constitutional law cases. It's a violation of the Fourth Amendment to the Constitution, which is the one about searches and seizures, because they're able to seize records and papers, private papers, without going before a court and showing probable cause. And it violates the Fifth Amendment. The Fifth Amendment, usually people think about the part about the right to not self-incriminate, but it also says that you have the right to legal defense, or the right to legal representation. And by telling you that you could not tell any person that you got the letter, pretty much precludes you from being able to talk to a lawyer. Now, of course, when I did this whole thing of like talking to the lawyers and then engaging the lawyers to bring this lawsuit, like I asserted my First Amendment rights and I asserted my Fifth Amendment rights, and I didn't do what they told me. I ignored the fact that they told me I couldn't do that. But I pretty much figured I was screwed because of that. And so that's, I guess, part of what I meant by earlier in our discussion, I think before this was officially the interview, but where I was saying about waiting for the other shoe to drop, or just living with stress and fear and tension for extended periods of time, and how maybe in some ways it prepared me for the pandemic, because, pandemic is scary. Like, the case literally went up and then down and then backwards and forwards, and then I basically stopped for a period of time when I got a partial, like, I sort of got a partial win, and I decided to just take a break from it for a while after like 10 years, right around the time when my kid was born. And then after I sort of got my wind back, I caught my breath, and then I decided to come back to it, because I still was not able to, I was not able to fully tell the story because I was still under a partial gag order. And then I spent the last 3 years or so of the case working with a legal clinic at Yale Law School. So it's run by law students at like the top law school in the country, supervised by attorneys who are law professors, as a learning experience for the young soon-to-be attorneys. The law students sued the government on my behalf to have them release me completely from the gag order. And in 2016, I fully won that case. We discovered later through reporting on national security letters that, like, just in a two-year period, they put out like 220,000 national security letters. If you do the math, that's like one letter per like somewhere between 1,000 and 1,500 people in the United States. And the claim is that every single one of those either had to do with counter-espionage, like trying to catch Russian spies or something, or counterterrorism. So to me, that already seems a little bit unbelievable on the surface, that there could be that many suspects in the country for those two narrow things. But it turned out, through reporting that the Department of Justice was forced to do by Congress, that a lot of those national security letters actually were super broad blanket orders for data. So it wouldn't just be like you, Henry, and your phone records. It would be, this is a real example, like a list of everyone that was in Las Vegas over New Year's Eve. You know what I mean? So like one letter, you would assume, my original assumption, 225,000 letters divided by the population of the country is 1 per 1,500 or 1,000 people or something like that. And that's if you assume a one-to-one relationship of a letter to a person. But when it turns out that some of the letters were for like hundreds of thousands of people's data, or some of them were for like the phone records of 10,000 people or something, it turns out that they were getting basically everyone in the whole country's information with these letters and evading the Constitution's requirements for like checks and balances on abuse. So that is like the central issue of why national security letters are bad, because law enforcement and the intelligence community, undoubtedly, I won't deny that they need to gather evidence when there's crimes that have happened or are likely to happen. You know, I think you'd have to be pretty radical to disagree with law enforcement ever having any rights to gather data. I mean, you know, murders need to be stopped, kidnappings need to be stopped, terrorism needs to be stopped. Of course, I'm totally on board with that. The problem, though, is that the system was set up with a very carefully calibrated set of checks and balances to prevent abuse. And the Patriot Act basically got rid of a lot of those oversights and checks and balances in the interest of expediency, is what they said, and it's probably true. They said, well, we can't wait. We can't wait one day for the judge to read our evidence and tell us yes or no. We just need it now. But the problem is that without checks and balances, well, there's no. It's like having no safety net, no backup parachute. You know, it's bound to lead to abuse, and it did. It led to massive abuses. So the cool thing about the case was a lot of abuse was exposed and became public knowledge. A good thing about the case was that judges repeatedly ruled national security letters to be unconstitutional. But a bad thing is that because we couldn't get to the Supreme Court, in part because what the government did was withdraw the letter, they said essentially, and it reminds me of like a kid playground game kind of thing, like do-over. You know what I mean? They said, okay, we're taking back the letter. We withdraw the letter we gave you asking for the data. So now you don't have standing to go to court and say that we're illegally searching anymore because we withdraw that letter. So now the only person that could maybe bring a challenge like that would be one of the other people who'd received the other 220,000 letters. That was just in a 2-year period. You know, most of those probably went to places like AT&T or Comcast or Verizon or banks or hotels or umpteen number of other types of businesses that could get these letters. But none of them ever said anything about it. I was the only person to ever say anything about it or bring attention to the fact that this was being done or to challenge whether this was legal or legitimate or not. All the other recipients of these letters just handed over the data. Now, the unfortunate thing about this whole case is because we couldn't get to the Supreme Court, that means that despite that multiple judges said it was unconstitutional, it doesn't actually stick. Like, it's not a binding ruling on the whole country. The judge that ruled that here in New York, I think it was technically binding on the Second Circuit, which is like New York and Connecticut, and I'm not sure what other states are in the Second Circuit. Maybe some New England states, I'm not sure. Maybe New Jersey. But the ruling was then sort of stayed. I think they call it staying it. Like, it means that he says, this is unconstitutional, but I'm not going to enforce on the FBI that they can't issue these letters anymore, pending their appeal. So that they were going to appeal to the next level of court. And then in the middle of, between those appeals, Congress amended the law and they changed it. They made a couple of little tweaks. So what that meant was by the time we got to the second level of court, they said, well, the law that you started suing about in 2004 doesn't exist anymore. Now there's this new amended law. So you need to go back to step one. This was 6 years into it. They said, you got to go back to step one and remake your argument based on that the law is now different. So that's what I mean about them pulling the rug out from under me and doing all kinds of stuff that I couldn't do. I couldn't just say, I withdraw, now, it's like, I'm going to rob a bank and now I'm on trial for robbing the bank. And I'm going to say, well, I withdraw my robbery. I no longer want to rob the bank. So therefore you have no beef with me anymore. That's kind of what they did to me. Anyway, long story short, this is why I do the Institute now and work on technical solutions, because litigation is really hard. It's really extremely time consuming. It's extremely stressful, and it's not necessarily fair to the small guy. I remember when I went and I spoke at the CCC, which is like a German hacker conference, and used to be in Berlin. At the time I went, it was in Berlin. It's in Germany always, but different cities now. It was the first time I really spoke in public about this experience. It was the first time I ever told everyone about it. I spoke on a stage in front of like 3,500 people or something in a huge auditorium. And I was terrified. And then after the speech, someone came up to me and told me that in Germany, because of their modern new constitution, unlike our old one, they didn't have to like prove standing. Like in the US, you have to show that you've been injured by a law before you can challenge it. They said in Germany, you can just go into this special constitutional court, which is right at the top and has a side door where you don't have to climb the ladder of all the different levels of court. And you can just say, this law is unconstitutional. You don't have to prove that you've been affected by it. You don't even have to prove that the law has been used. So I remember learning that other countries' court systems, that I couldn't have been, as I explained, I told this whole story in a long form. All these people who were German told me, oh, like in this country, they couldn't have pulled the rug out from under you like that because you don't have the same, they just have a different system.
Thanks for watching this short clip of the wonderful interview I did with Nicholas. There are other short clips you can find if a certain topic interests you, or the entire almost 2 hours is its own video as well, which I highly recommend you watch every minute of it. It is fantastic. It's also in podcast format under our surveillance report. Links for everything are below. I highly recommend checking them out if you enjoyed this clip. See you all next time, and thanks for watching.